Hello, my name is Rachel Kuhn. I'm one of the attorneys here at Weiss Law, and I handle most of our real estate practice. I get a lot of questions from homeowners who live in condominiums and HOAs. They'll often call me upset because their board made some type of decision without a vote of the owners. And usually that decision involves money. It always comes down to money. The board either decided to spend a lot of money on a repair project without input from the owners. They decided to take a big step like hiring a management company without a vote of the owners. They maybe adopted some rules, or the big one, they raised the annual assessments without a vote of the owners. And a lot of times owners are frustrated. They don't understand, how can the board do this to us without a vote or without our input? The truth is, your association is a nonprofit corporation in Ohio. As a nonprofit corporation, you are run by an elected board of directors. They are elected to make the day-to-day decisions that govern the association. I'm going to go over some times when owners actually get a vote and when your voice can and should be heard. Number one is at the annual meeting. You should be having an annual meeting every year. The main purpose of that annual meeting is to elect board members. So it's really important for that annual meeting that you show up. There's a lot of apathy. People are busy. They don't prioritize showing up at that meeting. Show up, vote, and vote for the people that you think are going to have the association's best interest at heart. Or more importantly, run for a seat on the board. If you want to be involved and you want to be making decisions, run for a seat on that board. We always need good board members on these homeowners associations and condominium associations. The second time that owners get to vote are amendments to your governing documents. Your association is governed by a declaration and bylaws, and to amend those documents generally requires a vote of the membership. Typically, the vote is 75% of the membership has to vote to pass an amendment. Your declaration or bylaws might have a slightly different number, but most of the time it is 75%. If your board wants to do something like restrict leasing within your community, a big one in HOAs, some declarations prohibit sheds or they prohibit pools, they prohibit fences. So we have to amend that language and take it out. Changing insurance requirements to bring your documents up to date with today's insurance industry, especially for condominiums. Those changes to your governing documents will require a vote of the membership. So that's the second time you get to vote. If you get those documents in the mail or you get a notice that there's a meeting to take that vote on those amendments, make sure you fill out that form and you show up. The third time owners might get to vote is on capital expenditures. A lot of association bylaws place a cap on the board's ability to make a capital expenditure. And a lot of times I see that cap at being $5,000 or $10,000. And what this means is that the board cannot spend above that cap to add something to the association or take away something that's already there, okay? So if you don't have a playground, and the board decides they want to add a playground, and that playground is going to cost $20,000. And you have a provision in your bylaws that says that the board can't spend more than $10,000 on a capital expenditure without a vote of the membership. Adding that playground would require a vote of the membership. Similarly, if they want to get rid of a tennis court because it's not used and it's in disrepair, and they're going to spend money to take away that tennis court, and doing so would cost above that capital expenditure amount, they have to get a vote of the membership. Where they don't have to get a vote of the membership is repair and replacement of capital items like for like. So if they're going to replace the roof, they don't have to get a vote even if it's above that cap. They're going to replace the siding on your condominium building because it's reached its useful life. They don't have to get a vote. But to add something new or take away something, they have to have that vote. The last time owners might be voting on something in an association is with respect to your reserve account. Ohio law, both Chapter 5311 for condominiums and 5312 for homeowners associations, requires the association to budget for the repair and replacement of major capital items. Again, your roofs, your sidewalk, anything the association is responsible to maintain, repair, and replace. They have to put away enough money and budget for the repair and replacement of those things, or they have to obtain a waiver of that requirement by a majority of the membership each year. So if your board decides that they are not going to fully fund your reserve account, they're not going to put away as much as they probably should be putting away to save up for your roofs or your concrete or whatever they need to be saving up to repair or replace, they're going to save less than what they need to. They can't do that without a majority of the members waiving that requirement, and it has to be done annually. So that is another time where you as an owner on a regular basis might have the opportunity to vote. If they are going to fully fund the reserve account and be putting away enough money, even if it means raising assessments to do so, that will not require a vote. It's only if we're going to waive fully funding the reserve account. And some common things the board will do that, again, gets owners a little upset that they didn't get to vote on: repair and replacement of major capital item. If the association is responsible for the roads and they're going to hire a contractor to replace the roads because they're in bad shape, they don't need an owner vote for that. Adopting rules. The board has the authority to adopt reasonable rules that govern the common elements. So if you are an association that has a pool, a clubhouse, any sort of common elements, they can adopt rules that govern those. They can adopt reasonable rules that govern holiday decorations, signs, those type of things. They don't need an owner vote to adopt rules as long as those rules don't conflict with what's in your declaration and bylaws. And just general operational business decisions don't require an owner vote. So things like hiring a landscaper, hiring a management company, hiring anybody who's going to do business for your association, putting together the budget and determining how much assessments are, again, those in most cases will not require an owner vote. So if you want to have a say in those things, best thing you can do is run for your board. If you're an owner in a condominium or homeowners association and you don't see your board doing some of these things that should require an owner vote, then you should pick up the phone and call me and we can talk about what your rights are. So if your board is not holding annual meetings, if they're not electing a board, if they are making large expenditures to add things to your association without taking a vote to the membership, and you do have that cap in your documents, and they're ignoring it, if they are just making changes to your governing documents that are substantial without a vote of the owners, they're not funding your reserves and they're not getting that waiver, that's a good time to pick up the phone, call me, we can talk about what your recourse is as a homeowner. So if the board is not holding meetings, or if they're not doing what they're supposed to be doing, your governing documents, typically it'll be in the bylaws, will talk about how those board members can be removed. It'll require the owners to call a special meeting, and it will tell you how many owners, sometimes it's a percentage, need to sign a petition to call a special meeting. And then it will have in there a percentage of the membership that has to vote to affirmatively remove a board member at that special meeting. Most of the time it is 75%, and that is 75% of the membership, not 75% of the people that show up. So that is how we can remove a board that is not doing their job. If somebody's term is up and they're running for re-election and they're not a good board member, obviously run against them, get the support of your neighbors, get proxies if they can't be at the meeting, and then you can vote their proxy. That's the other thing that you could do if your board's not doing what it's supposed to. Get on the board. I want to hear from a lot of owners when I make the suggestion of, hey, if you don't like this, run for the board. Well, I'm busy. I know it can be a time commitment, but really if you truly don't like how they're doing things or don't see them doing things the way that you would like, the best thing you can do is get yourself on the board and get some of your other neighbors that also don't like what they're doing onto that board. And then, you can kind of steer the ship and do things correctly. Ultimately, if we can't get new people on a board and get things running smoothly that way, sometimes we do potentially have to file lawsuits against the association. I will represent groups of owners who need to sue their homeowners or condo association because it is doing a number of things incorrectly with the finances and the voting and all of the procedures. And that can be a long and involved process, but sometimes that is the last resort. We do have to take that last step if we can't resolve the problem by calling a special meeting, trying to elect a new board, getting good people on the board. I always will like to try to problem solve and strategize and resolve an issue before we have to just resort to filing a lawsuit.